Good morning, I'm Gary DeWaal, and this is Bridging the Week for April 16th to 20th, and today is April 23rd, 2018. A California federal court may be poised to dismiss an enforcement action brought by the Commodity Futures Trading Commission that could challenge the agency's view of when finance sales of commodities to retail persons are subject to its oversight, as well as the circumstances when the Commission may bring an enforcement action against persons for allegedly engaging in the use or employment of any manipulative or deceptive device. Separately, the New York Attorney General asked 13 cryptocurrency exchanges to disclose a trove of information about their operations when only 5 of the enterprises have ever obtained authority to conduct a virtual currency business from or to persons in the state. A thaw in international developments emanating from North Korea seems to be corresponding to a thaw in the weather in New York City. So I can enjoy the warmer temperatures here. Let's get started. The federal court judge hearing the enforcement action by the Commodity Futures Trading Commission against Monex Deposit Company and other defendants for alleged fraud in connection with their finance sale of precious metals to retail persons issued a tentative order in late March dismissing the Commission's complaint. The court's preliminary decision, which could be issued as is or modified, said that actual delivery of precious metals in finance transactions to retail persons falls outside the CFTC's authority, even if the seller retains control over the commodities. Moreover, the court held that the CFTC could not use the broad Anti-Fraud and Anti-Manipulation Authority enacted as part of the Dodd-Frank Wall Street Reform and Consumer Protection Act, except in instances of fraud that affects or potentially affects the market or in cases of fraud-based manipulation. Last year, the CFTC sued 3 Monex companies and Louis Cabrini and Michael Cabrini, the firm's principals, in a federal court in Illinois. The commission alleged that, in connection with Monex's precious metal transactions, retail clients purchased and sold precious metals, paid only a portion of the purchase price, and either borrowed the difference or borrowed the metal. In its lawsuit, the CFTC relied on 2 bedrocks in its perceived current arsenal of enforcement tools: the so-called actual delivery requirement for retail commodity transactions to be outside the CFTC's jurisdiction in situations where such persons' transactions have been financed. In such circumstances, actual delivery to the retail persons must occur within 28 days. And the alleged requirement that there is a prohibition against all transactions involving commodities in interstate commerce that involve any manipulative device, scheme, or artifice to defraud. If the CFTC's view of these tools is upended by the California court, it could have a material impact on the CFTC's enforcement reach going forward, including in the virtual currency space, where its enforcement actions so far have relied extensively on both these bedrock interpretations of existing law. Last week, the New York Attorney General's office requested information from 13 cryptocurrency exchanges regarding their operations. Only 5 of the exchanges possessed either a BIT license or a New York Limited Purpose Trust Company charter that would appear to enable them to conduct a virtual currency business from New York or to New York persons. Generally, the New York Attorney General's questionnaire seeks information on the exchange's ownership and control, basic operations and fees, trading policies and procedures, practices regarding outages and other suspension of trading, internal controls, privacy and money laundering, and protections against risk to customer funds. Curiously, the New York Attorney General also asked for each exchange's application to the New York Department of Financial Services for a limited purpose charter or BIT license and all supplemental submissions. In a letter to all the exchanges, the New York Attorney General said that after reviewing all received material, it would, quote, disclose certain information in a publicly accessible format, end of quote, although it did not detail which specific information it was referencing. The New York Attorney General indicated it would disclose the identity of any platform that did not provide, quote, meaningfully complete responses. It's hard to imagine that New York is so flush with taxpayer funds that it can afford two regulators overseeing virtual currency activities. The New York Department of Financial Services has already taken the lead in this area through regulations governing virtual currency businesses. New York already requires cryptocurrency exchanges to potentially qualify as both money transmitters and obtain a bit license to do business from or to residents of the state. Dealing with two regulators is an additional unnecessary burden. And finally, Virtu Financial Global Markets agreed to pay a fine of $75,000 to resolve a disciplinary action brought by the Chicago Mercantile Exchange, claiming that on October 16, 2015, because of a programming error, an automated trading system malfunctioned and sold a euro-dollar futures contract, causing a 74-tick price movement. The exchange claimed that although Virtu's ATS automatically locked down after the aberrant activity, the firm unlocked the ATS by error, causing further price anomalies. Separately, DBF-GP LLC, the general partner of a hedge fund, and David Lambert, the firm's manager, consented to a fine of $20,000 by CBOE Futures Exchange and disgorgement of $19,500 in connection with Mr. Lambert's trading for DBF, whereby he purportedly entered orders for CFE VX futures that prompted price changes on CBOE's corresponding options exchange. Mr. Lambert then allegedly traded against the options exchange's participants at the non-bonafide prices and canceled his futures orders. DBF and Mr. Lambert agreed to be jointly and severally liable for the CFE fine. Mr. Lambert also agreed to a 6-month trading suspension on all exchanges owned by CBOE Global Markets. The alleged conduct occurred on several occasions from July 30th through September 5th, 2014, CFE alleged. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website, www.bridgingtheweek.com. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.